Hello, and welcome back to Coin Lady channel. Do we have a problem here? Summary judgment in the action between the SEC and Ripple was granted by Judge Torres. Is she going to talk about how XRP is traded on the secondary market, which is of real interest to XRP investors? Or is her focus going to be limited to cases involving Ripple-related transactions? If you own XRP, that has significant implications. When it comes to the nature of secondary market transactions for the library credit token, the judge who took the minimalist approach, as he described it, in the case of the libraries did not elaborate. Not a good thing, that. That was terrible, both for the price and for the markets. During the remedies phases of the case, attorney John Deaton chimed in as an amicus, and the judge agreed with him that secondary market transactions would be excluded from the ruling. To be absolutely crystal clear, there would be no such thing as clarity without him. The big question is whether or not Judge Torres will follow suit. Simply put, I fail to see how she circumvents this. Even more convincing and reassuring is the viewpoint offered today by attorney John Deaton. He has taken the tack that Judge Torres is quite likely to rule on this. Not everyone agrees with me, and I certainly can't claim to be certain, but I think attorney Deaton makes a pretty strong case here. After I finish going through it here, you can give me your thoughts. But even if she doesn't touch on it, I can't help but keep coming back to this concept. It will probably be discussed throughout the treatment phase. There are other, more compelling reasons than her inability to avoid it. If attorney Deaton is serious about addressing this in summary judgment, she must explain why. And in fact, due to the SEC's trial strategy or, well, not trial strategy exactly, but a strategy they adopted and all the pre-trial material leading up to the trial. I find it intriguing that attorney Deaton argued that the judge really doesn't have much of an option except to address it. But there is something I need to clarify before we go any further. I come from no financial or legal background. You shouldn't buy or sell anything based on what I say or write because I'm not a lawyer or a financial advisor. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. Okay, then. A member of the XRP community at Expected started it all with a comment on a tweet in which he mentioned attorney Mark Fogel, a former member of the SEC. Judge Torres's decision in the SEC, according to attorney Mark Fogel, a former regional director of the SEC in San Francisco. The problem of secondary market trading is unlikely to be resolved in the v. Ripple case. Do you think so too? The future of XRP's pricing is anyone's guess. Like, maybe Ripple takes a technical loss and there's no mention of secondary market trades? Currently, I don't think that's helpful for XRP's price. Now, if Ripple finally loses on a technicality and has to pay a fine or something like that. However, XRP is not in the dark. In my opinion, the price of XRP will increase dramatically. So, depending on Judge Torres's strategy, this will have an immediate effect on our collective wealth. That's what I think, at any rate. This is what I've been sensing will happen, attorney Jesse Hines says now. We don't want Judge Torres to address this, but that seems unlikely according to Jesse Hines' assessment. In reality, this goes back to June 8th in a different thread from attorney James Murphy, which I actually addressed in a prior video, so I won't be covering it here. Excellent yarn. Sorry if I'm getting off topic, but I simply don't feel like going over that again for the sake of this video. To put it simply, he was offering his opinion. To which Jesse Hines responds, don't you feel that it's likely that the court will just rule on whether the sale of XRP was a security offering and pass on making a decision regarding secondary market sales in the digital asset itself? Because neither of those things were alleged in the complaint, as far as I can tell. James Murphy, another lawyer, answered attorney Hines by saying possible. That would have the appearance of a library, I suppose. That's about what I was getting at when I started the video, so yeah. It's almost guaranteed to show up during the solution phase if it isn't dealt with beforehand. So, I'll agree that it's at least plausible, but I'm more convinced by attorney Deaton's argument. And I can't recall ever hearing him debate about anything. This is the first thing he's mentioned on Twitter so far today. And it's really interesting. Yes, this is worth your time. This was just provided this afternoon by John Deaton, an attorney. As for what you said, I disagree with it, he says. Until she puts her thoughts down on paper, no one will know. A judge will often just discuss the issues that require their attention. In other words, the judge's ruling in the library case is consistent with your findings. According to him, less is more, so when lawyer John Deaton in the remedy portion asked the judge to clarify that the asset itself is not the security, he complied. He disclaimed wanting to commit to such an extreme position. He preferred simple, elegant design. And I get why most judges want to do that, too. Going even slightly over the bounds of what ought to be addressed by law can land you in hot water. And now, Deaton's legal counsel says, on the one hand, she doesn't need to consider secondary market sales to decide whether Ripple offered/sold XRP as an investment contract, and she might opt to decide the much narrower issue without addressing secondary market transactions. However, I think she will discuss it because of the following 3 reasons. Here they are in full. First, and this may be something he's stated before, but I've never seen him articulate it, is that I find it really fascinating that he believes that. He argues that she must comply since it is implied in the SEC's summary judgment motion. In its summary judgment brief, the SEC argues that buying XRP constituted participation in a common venture with other buyers of XRP and Ripple. This is a direct quote. And now, for a second quotation. Buying XRP is like putting money in the same pot as other XRP holders and Ripple. According to the SEC's lawsuit, even if XRP is recognized as legal tender in the future, it will still be considered an investment contract. He's also sporting a small facepalm emoji, and with good reason. If you own XRP, and I know that most of you do, then the SEC considers us to be in business together. That settles it. We are definitely in the same business. It's ludicrous, yet that's what they're pushing for now. The implication of his argument is clear. Right. Since they are making that claim, it follows that there are consequences for secondary markets. Right. This is where Attorney Deaton will resume. He further claims that the SEC contended that XRP is a symbol of the joint venture that all XRP holders have with Ripple. All sales are now under question according to the SEC, as their premise is not restricted to Ripple sales. That is a major consideration. The way you put it made me realize that, sure, they have done that. And I was familiar with what is now commonly called the embodiment theory. And this is simply everything that has ever happened or will happen in the future that involves XRP. Contracts representing investments are always a good idea. So, that means secondary market trades as well. Even if it wasn't formally documented by the SEC, the following points should be taken into consideration. What they're saying is valid, thus it's important to respond to it. I get what he's getting at, and it's an interesting argument. This is what I meant when I said the SEC may have grabbed loss from the mouth of triumph, Attorney Deaton adds. In my judgment, she would be engaging in a more extreme form of judicial activism by going out of her way to avoid discussing secondary transactions and the token itself. It's true that judges have a penchant for simplicity, and I get why many lawyers have pointed this out. Oh, right. That makes a lot of sense, I thought to myself after hearing Attorney Deaton make that point. So, no promises can be made. Also, it's possible that she doesn't go into detail about secondary market trades, which is something I'd consider a missed opportunity. But it will still be discussed during the remedies phase, even if that causes XRP's price to drop. So even if that happened, the world wouldn't end. I really hope that doesn't materialize. I can't stand watching my wealth become eroded any longer. Where do you stand? 2. She would be silent for all intents and purposes. Regardless of the amicus brief I filed on behalf of XRP investors. Spend some keystrokes on amicus briefs from JetBlue, Coinbase, the Blockchain Association, the Chamber of Digital Commerce, and others. Third, Judge Torres is certainly aware that I entered as amicus and argued during the hearing on secondary market sales during the penalty phase of the library case. I will likely file a move for leave to participate and be heard if Ripple loses its summary judgment and she fails to address secondary sales. I can't assume she'll let me in even though the library judge did. The SEC also had no issues with the library and amicus briefs. I asked my local counsel, what are the chances the SEC will object to me now, so they wouldn't suspect it was me? I have faith that Judge Torres will address the foregoing in her ruling. Yes. Yes, I think so. What happens next remains to be seen. I don't think she's trying to avoid this, though. And she witnessed the whole thing with the library case. There is consequently no assurance of any kind. But I would admit that I am at the very least hopeful. Furthermore, if you consider how eager and willing she has been to have every voice heard, you'll see that she has accepted a total of 17 distinct amicus briefs, 2 of which ultimately did not file. Attorney Deaton is speaking for an additional 76,000 freeholders. This situation warrants optimism. Even though it wasn't explicitly specified, this is the sort of thing that needs to be dealt with right away, so here it is. This is because of the SEC. So that's the point. Again, this is why I was confused after Attorney Deaton stated it in such a way. Now, we shall see. Please share your thoughts in the space provided below. Oh, I'm sorry, I misspoke. No sense of confidence compels me to assert that she will inevitably bring it up in conversation. If I had to wager money on it, however, I'd put my money on the side of yeah, I think she will. I may be completely wrong. That could be the case. However, I can't say that I'm completely and totally convinced. However, I agree with Attorney Dean and find his arguments convincing. The last thing I'll say is, that's the way I'd lean if I had to gamble on it. Again, I invite you to share your thoughts in the space provided below. I am not a certified financial planner. Nothing I say or write should be used as a basis for making financial decisions. If you want to see more, click the subscribe button. See you later, bye.